You too. Thank you. Appreciate your time.
Thank you. You are free to leave.
Thanks.
Andrew Irving. Good morning, sir. Come on up.
Morning.
Are you going forward today without benefit of a court-appointed attorney?
Yes.
You've met with the prosecutor. It says you're going to plead guilty to an added charge of drove while license suspended, revoked, or denied first offense. Is that your deal?
Yes.
You understand the possible penalty for the charge? Understand the possible penalty for that charge?
Yes.
You understand that the Secretary of State's probably going to put 2 points on your record? All right. And did you read your rights form?
Yes.
Understood those rights? And the options they give you?
Yeah.
Understanding all of that, are you pleading guilty freely and voluntarily today?
Yes, I have.
Sir, did you drive a vehicle in Huron Township on February 8, 2006?
Yes, I did.
Was your license suspended, revoked, or denied at the time?
Yes.
I'll accept your plea and dismiss the original charge. You're working?
Yes.
Where do you work? How long have you been there?
Public waste. I've been there 23 years.
Good. Anything else you want me to consider before I sentence you? Your license still suspended, I assume?
It was an emergency. Apologize.
Okay. All right. Mr. Irving, I think I said this. I dismissed the original charge that was issued to you. On today's file, fines and costs, $500 and 4 days on the court work program. Work program is assessed as an alternative to jail. You pick which 4 days you want to work. We'll give you a schedule. You got to be here each of those days at 8 o'clock in the morning. Can you pay the $500 today?
Yes.
Go on downstairs, take care of the money, get a smile from the cashier, and they'll sign you up as well. Good luck to you. No magic answer. I'm just giving you a chance to talk if there's anything you want to share.
Thank you.
All right.
Yeah.
Can you stay out of contact with Mr. Ellis?
Oh, yeah. I ain't got no reason to go near him,
All right.
other than driving by his house on the way home.
Well, just drive by like this and you're fine. You can't drive by like this.
I ain't got no reason, had no reason.
All right.
Notice that.
All right. I'll delay sentence for 6 months. Stay out of trouble. No new criminal charges. No contact with him. Court costs are assessed amount of $500. Can you pay it today? Can you pay $500 today? Go downstairs and make arrangements. They'll tell you what your options are.
Go downstairs.
Andrew Irving.
Oh, yeah.
You had a question about work program, sir?
Yeah. I didn't realize that the 4 days work was during the week. I work 4 a.m. to 2:30 in the afternoon, Monday and Friday.
Who you work for?
Republic Waste.
Oh, you said that.
Anything else I could do? I mean, I can go try to get them to change my days off, but I don't know if they will or not.
Heather, what's Vanessa's number?
17.
Hey, do you have any idea how close we are to scheduling our weekends? No, I mean, the guys we're hiring, yeah. All right, so I think I'm just gonna have Irving come down and schedule and just schedule them for, you know, like, or even if you want, just give them a review to contact you to set up, but I'm thinking just schedule, some weekends in April. Yeah, yeah, okay, all right. All right, so we're expanding the weekend program, we're just not there yet. So I'm gonna have you go down and set up a schedule to start like after next month. So after March, start it in April. All right?
What makes this case powerful isn't yelling, theatrics, or dramatic sentencing. It's the tension of uncertainty. This wasn't a moment where the judge destroyed the defendant with years in prison. Instead, it was something far more psychologically intense, a conditional freedom hanging by a thread. Edward Michael Puce wasn't in court for something minor. He was already on probation for a serious felony, possession of methamphetamine. That alone means the court had already extended him a second chance. Probation is not a right, it's a privilege. It's the court saying, we believe you can live outside jail, but you must follow strict rules. And those rules were clear. The new allegations weren't small technical mistakes. Driving without a license, no valid plate, no insurance, open alcohol in the vehicle, possible possession of drug paraphernalia, failure to report police contact. Whether he agreed with them or not, these are exactly the kinds of behaviors probation is designed to prevent. When someone is on probation for a drug-related felony, the court expects heightened responsibility, not more law violations. But here's where the moment turns. Instead of immediately revoking probation, the judge slowed everything down. He carefully explained the defendant's rights. He clarified the difference between contesting the allegations and accepting responsibility. He warned him about representing himself. He even granted an adjournment so he could seek private counsel. That's not a judge going nuclear, that's a judge ensuring due process. Then came the critical pivot, the drug test. The judge's message was unmistakable. Your freedom today depends on what's in your system right now. Not next week. Not next month. Right now. That's powerful because it removes excuses, it removes arguments, it removes narratives. A drug test doesn't debate, it doesn't speculate. It answers one simple question. Are you complying with probation conditions or not? And the consequences were crystal clear. If he tested negative, he would walk out and return on the scheduled date. If he tested positive, his bond would be revoked and he would go directly to jail pending the hearing. That's accountability in real time. There was no shouting, no humiliation, no dramatic speech. Just a structured, lawful decision, prove you're following the rules or lose your freedom. What stands out most is the judge's tone. He wasn't hostile, he wasn't emotional, he was firm, procedural, and precise. That matters. Courts function on structure. When someone is already on probation for a felony drug offense, the system does not require perfection, but it requires compliance. The defendant expressed frustration with his appointed attorney. The judge addressed it calmly. He allowed him to waive counsel. He explained the risks. He documented the choice. Again, process over emotion. This case becomes a psychological countdown. The defendant leaves the courtroom knowing exactly what is at stake. A single test result determines whether he sleeps at home or in a jail cell. There's something uniquely intense about that. Prison sentences are dramatic, but conditional freedom, that suspended moment between hope and collapse, can feel even heavier. In the end, this wasn't about traffic violations. It wasn't even about the pending charges yet. It was about whether someone already given a second chance was honoring it. Probation is built on trust. The court extends it cautiously. And when that trust is questioned, the system responds carefully but firmly. Now everything rests on a simple biological fact. Pass the test and the fight continues. Fail it and the jail doors open.